Welcome to the Foul Play YouTube channel.
Hello, everyone. We have a special edition of the open mic today. As everybody knows, the state has replied to Zellner. We did finally get a copy of the reply from Laura ML on Twitter. We'd like to thank her very much for sharing that so that we could get a read through on it and maybe do a little discussion afterwards. So I'm going to pull this over here and we'll get to it. Let me get that pulled up there. No, that's wrong. Pull over here. There we go. Let me know when you all can see that.
There, we got it.
Can you see it?
Mm-hmm. Yep.
Okay. So this is dated. Also, you can see it's dated. Can everybody? Am I zoomed in far enough?
I think so, but
Yeah, it looks good.
yeah, it's fine.
I'll pop it in just a little bit closer there. Anyway, this is the reply signed by Lisa Comfort. This is the 16th. So we'll get right to it. State of Wisconsin Court of Appeals, District 2. Response in opposition to Avery's fourth petition to stay this appeal and remand this case to the Circuit Court. Introduction. Plaintiff Respondent Steve, State of Wisconsin, opposes Defendant Appellate Stephen A. Avery's fourth petition to again stay this appeal and remand this case to the Circuit Court for consideration of yet another new Wisconsin Statute 974.06 motion alleging that the state violated Brady v. Maryland by alleging failing to inform the defense that a Thomas Sowinski purportedly called law enforcement on November 5, 2005, to say that he saw Bobby Dassey moving a car similar to the victim's car. The motion on its face shows that it was filed in a violation of Wisconsin Statute 802.05, applicable here in via Statute 809.84. That's a rule. Because it was filed for an improper purpose and without a reasonable inquiry into its factual basis. Okay, moving on. Staying this appeal and remanding for this litigation of such a motion would result in further unnecessary delay and litigation. This appeal has been languishing for nearly 4 years now due entirely to Avery's repeated request to return to the Circuit Court to litigate procedurally barred claims that have no factual support. It is responsible to conclude at this point that he is not pursuing these claims in good faith, but is merely throwing the proverbial spaghetti at the wall to see what sticks and delay resolution of this case. Whittemire versus Expedia, case number. Indeed, Avery's new claim is not only unsupported by even a suggestion of corroborating evidence, this claim is also mutually exclusive with many of the other claims Avery has pursued in the Circuit Court and on appeal. All these allegations cannot be true. Avery's reckless disregard of the truth or falsehood of these allegations he is submitting to the courts alone should be reason enough to deny this petition for remand. Moreover, this case has now been fully briefed in this court for nearly a year and has been submitted to this court awaiting a decision for nearly 5 months. Remanding this case to the Circuit Court to again allow Avery to develop another entirely new constitutional claim is not necessary to decide this fully briefed and long submitted appeal. It would be inefficient and a waste of the court's and the parties' considerable resources that have already been expended and further delay this appeal's resolution. If Avery wishes to pursue yet another claim, the appropriate course is to either wait until this appeal is concluded, conduct a reasonable investigation, and file a new Wisconsin Statute 174.06 motion, or dismiss this appeal so he can pursue it now. If Avery has sufficient reason why this new claim could not be raised in any of the previous 6 motions and some facts to support it, then the claim will not be procedurally barred when this appeal is concluded. If not, the claim is unquestionably procedurally barred already, and another remand would serve only to further delay this litigation and add another incongruous claim to Avery's appellate brief. Avery has dragged this appeal long enough. He should either dismiss this appeal, conduct a reasonable investigation into this new claim, and pursue it in the circuit court now, or this fully briefed, submitted, and years stagnant appeal should proceed. Background. In 2007, a jury convicted Avery of first-degree intentional homicide for the murder of Teresa Halbach and for possession of a firearm as a felon. His direct appeal concluded when the Wisconsin Supreme Court denied his petition for review in 2011. In February 2013, Avery, pro se, filed a Wisconsin Statute 974.06 motion alleging that the state had interfered with his ability to confer with his attorneys, and that the state impermissibly commented on his silence during the closing argument, that he was deprived of a fair tribunal and ineffective assistance of counsel. The circuit court appointed an attorney to investigate the claims and ultimately denied the motion without a hearing in November 2015. In June 2017, Avery filed the Wisconsin Statute 974.06 motion at issue in this appeal, alleging that a multitude of constitutional errors occurred in his prior proceedings. The circuit court denied his motion without a hearing on October 3, 2017. Avery then filed a motion to vacate judgment on October 6, 2017. He additionally filed a motion for reconsideration on October 23, 2017, followed by several supplements to that motion between October 31st and November 17, 2017. The circuit court denied all of these motions without a hearing on November 28, 2017. Avery filed a notice of appeal from the circuit court's final written order on November 30th, 2017. On June 7, 2018, this court retained jurisdiction but remanded this case to the circuit court to allow Avery to file another Wisconsin Statute 974.06 motion to litigate a Brady claim. The circuit court denied that motion without a hearing as well, and the record was transmitted back to this court on September 25, 2018. On December 17, 2018, Avery filed another petition to stay this appeal and remand the case to the circuit court for Avery to litigate a motion for post-conviction DNA testing of bone fragments collected before trial pursuant to Wisconsin Statute 974.07. On December 28, 2018, this court denied the petition, stating that the scope of this appeal is limited to a review of the circuit court's orders denying Avery's Wisconsin Statute 974.06 motions, and therefore good cause to remand had not been shown. Order as of 12/28/18 at 2. This court gave Avery a further extension to February 1st, 2019 to file his initial brief. On January 24, 2019, a week before his initial brief was due, Avery filed a third motion to stay this appeal and remand the case to the circuit court. This time, he sought to pursue a new claim that the state violated his due process rights by releasing a portion of the potentially human bone fragments to the Halbach family for burial, roughly 5 years after Avery's trial. This court again remanded the case to the circuit court to allow Avery to pursue this additional claim. The circuit court denied it without a hearing on August 8, 2019. This appeal then finally proceeded. The briefing was concluded on June 26, 2020. On November 9, 2020, the case was submitted to the court on briefs. The only step left in the appeal is a decision from this court. On April 12, 2021, long after the briefing had concluded and after the case had been submitted for this court for 5 months, Avery submitted yet another motion for remand. This time he claims that a new witness, Thomas Sawinski, had come forward to post-conviction counsel on April 11, 2011, and said that while he was delivering newspapers to the Avery salvage yard on November 5, 2005, he saw Bobby Dassey and an unknown older man pushing a RAV4 uphill. Avery claims that Sawinski called the Manitowoc police to report this later in the day, but the police were not interested in this information. Avery claims the state suppressed this information and therefore violated Brady, 373 U.S. at 87. He seeks to remand to pursue this claim in the circuit court. Relevant law. Avery is permitted to petition this court for remand to the circuit court for action upon specific issues pursuant to the Wisconsin Statute 808.075, subsection 5. The decision to remand is left to this court's discretion. See State v. Meyer. The rules of the civil procedure apply to the appeals and to litigation of Wisconsin Statute 974.06 motions, provided they do not conflict with any specific rules of procedure spelled out elsewhere for such actions, and the context of the rule not manifestly require a different construction. As relevant here, Wisconsin Statute 802.052, Section 2, provides that presenting a submission to the court, an attorney is certifying that to the best of that person's knowledge, information, and belief formed after an inquiry, reasonable under the circumstances, all of the following. A, the paper is not being presented for any improper purpose, such as to harass or cause unnecessary delay or needless increase in the cost of litigation. B, the claims, defenses, and other legal contentions stated in the paper are warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law or the establishment of new law. C, the allegations and other factual contentions stated in the paper have evidentiary support or, if specifically or so identified, are likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. The purpose of the statute is to place a professional obligation on the attorney as an officer of the court to satisfy herself that there are grounds for the action, defense, or motion. Gaddis v. Lacrosse Products. The duty to conduct a reasonable inquiry mandates that an attorney validate the facts alleged being before a proceeding with a claim. Bellish v. Saminsky. The reasonableness of an attorney's inquiry into the facts supporting an allegation is determined by considering the following factors. 1. The amount of time the attorney had to investigate these claims. 2. The extent to which attorney had to rely upon his or her client for the underlying facts. 3. Whether the case was accepted from another attorney. And 4, the complexity of the facts. The provision has intentionally been crafted to replicate Federal Rule of Civil Procedures 11. See Riley v. Isaacson. Accordingly, courts can also look to cases interpreting that rule when applying Wisconsin Statute 802.05. Argument. Number 1. Remaining this case for Avery to pursue another new constitutional claim at this late juncture would be inefficient and unduly prolong this appeal. Avery again asked this court to stay his appeal and remand this case to the circuit court so he can litigate another new Wisconsin Statute 974.06 motion. The issue Avery claims he would like to pursue is an entirely new claim, alleging a Brady violation based upon a purported new witness who provided post-conviction counsel with an affidavit on April 10, 2021, alleging that he told law enforcement about seeing Bobby Dassey moving a car on November 5, 2005 that resembled the victim's vehicle. As before, Avery does not seek remand for fact-finding on a specific issue raised in his earlier motions. His motion is another request to pursue a new constitutional claim. Avery admits that this is a new issue that counsel purportedly discovered on April 11, 2021. Avery's motion 1. This case is now distinctly different procedural posture than it was when this court granted Avery's previous motions for remand in the name of the judicial efficiency. However, this case has been fully briefed since June 2020. It has been submitted to this court for a decision since November 9, 2020. The parties have already expended an enormous amount of time and effort on briefing this appeal. Presumably, this court has already dedicated a considerable amount of time, this court's scarce time and resources, to addressing the issues already briefed as well. Given that this appeal is nearing its end rather than in a pre-briefing posture it was when Avery previously sought remand, it makes more sense to conclude this proceeding and for Avery to file a new Wisconsin Statute 974.06 motion once this case is remitted to the circuit court. As previously noted, a Wisconsin Statute 974.06 motion at any time. Wisconsin Statute 974.06 Section 2, and if the court finds a grounds for relief asserted which for sufficient reason was not asserted in a previous Wisconsin Statute 974.06 motion, the new motion is not subject to the procedural bar of State v. Romero-Gorgiana. If Avery can establish a sufficient reason for failing to raise this claim in the motions currently under review, the claim will not be barred, and he can file a new Wisconsin Statute 974.06 motion once this appeal is concluded. If he cannot establish a sufficient reason for failing to raise this claim under the claim already waived. I'm sorry?
Yeah, we did. Tell Jack.
You lose sound?
What the hell happened?
He's still talking there.
Can you hear me now?
Yeah, well.
Can you hear me now?
Oh, I can hear you now.
Yes.
I don't know what's going on.
We can hear you now.
Okay. Let's take a drink here and continue on.
Well, we missed,
What do you want me to go back to?
I don't know, maybe what the page ahead, guys. I don't know where everybody else lost it.
I'll start at the bottom of page 12.
Okay.
As previously noted, a Wisconsin Statute 974.06 motion may be made at any time. Wisconsin Statute 974.06 Section 2, and if the court finds a ground for relief asserted for which sufficient reason was not asserted in a previous Wisconsin Statute 974.06 motion, the new motion is not subject to the procedural bar of State v. Escalona-Narhana. If Avery can establish a sufficient reason for failing to raise this claim and the motions currently under review, the claim will not be barred, and he can file a new Wisconsin Statute 974.06 motion once this appeal has concluded. If he cannot establish a sufficient reason for failing to raise this claim earlier, the claim is already waived and the procedure bar already applies. It would unduly prolong these proceedings further to remand now after considerable time and effort has been expended by the parties and this court and this appeal nearing its conclusion. The court should deny Avery's request for remand. 2. Avery did not conduct a reasonable investigation into his new Brady claim before filing this motion in violation of Wisconsin Statute 802.05. At a minimum, the reasonable inquiry standard requires that at least some affirmative investigation on the part of the signer. False swearing is a felony. Wisconsin Statute 946.32, an Avery's attorney has an ethical duty not to present false statements to the public. The state and the court, Supreme Court Rule 20.3.1, Avery's motions shows, however, that his attorney conducted no affirmative investigation into this claim before filing this motion for remand. Avery claims in his motions that Mr. Sawinski came forth on April 11, 2021. Avery then filed the motion at issue here on April 12, 2021, with only factual support of alleged for it in an affidavit from Sawinski himself, full of vague allegations. Avery's motion does not state that his attorney made any effort to substantiate this claim. His attorney did not attempt to perform an open records request with the Manitowoc County to see if the conversation ever occurred or whether any record of if it existed before filing this motion. She did not try to learn or who this female officer Sawinski claims he spoke to might have been, or even which female officers were employed with Manitowoc at the relevant time. She apparently did not press Sawinski for any specifics about this allegation that could allow her or the state to investigate it. Indeed, Avery's attorney apparently did not perform so much as a phone call to try to back up this information before filing this motion. There is no excuse for this lack of verification. There was an ample time to investigate this allegation as explained. There was no time for limit for bringing Wisconsin Statute 974.06 motion, and if Avery has sufficient reason for failing to raise this claim in his previous motions, it is not procedurally barred. If he does not, the claim is already procedurally barred, and pursuing this motion for remand is a fruitless endeavor anyway. Avery's attorney did not have to rely on Avery for the factual information underlying the motions. Indeed, nothing in Avery's motion suggests he is even aware of the story, let alone that he provided any facts about it. And as mentioned, there were several ways to investigate whether there was factual underpinnings for this tale. It was not impossible to investigate such that Avery's attorneys had to rely on Sawinski alone. The case did not originate with a different attorney, and post-conviction counsel had barely made it secret that she had been pursuing post-conviction relief on Avery's behalf for the past 6 years. And finally, while this case is complex, the allegations relayed by Sawinski and underlying elements of a purported Brady violation are not. To perform an adequate investigation before proceeding with a claim, it is clear that an attorney may not simply rely on his or her client's word. It follows that neither may an attorney rely simply on a word of a person like Sawinski, someone who has appeared out of the blue for the first time 15 years after this case began and long after Avery's appellate brief was filed. This despite extensive media coverage of the case, particularly during particularly the 5 years this post-conviction proceeding has been proceeding, and just fortuitously happened to provide the exact exculpatory story Avery has been seeking, yet for some unexplained reason, he failed to provide it to Avery's attorney until now. The need for an attorney to approach such claims with skepticism and to at least conduct some type of investigation before filing an affidavit attesting to this story's veracity is particularly heightened, where, as here, the attorney has offered a $100,000 reward for such information. A paper filed in the best of faith, even when the lawyer is convinced of the justice of the client's cause, is sanctionable if the counsel neglected to make a reasonable inquiry beforehand. The investigation need not be to the point of certainty to be reasonable. Nonetheless, the signer must explore readily available avenues of factual inquiry. A statement that is offered as a positive fact, but is actually an extravagant inference from vague recollection, does not satisfy this requirement. Avery's attorneys did not conduct a reasonable inquiry into this claim, denying a remand of the situation is appropriate. Just 1 second, I'm getting a drink. Number 3. Avery's many remand requests have been filed for the improper purpose of warranting denial of his latest request. The obligations listed in Wisconsin Statute 802.05, number 2, are independent, meaning that the statute has been violated if any of the prongs has been violated. Avery's disregard for Wisconsin's rules of procedure and his persistent serial filings show that they have both been made for the improper purposes to delay the proceedings, to continually change his position to make it difficult for the state to respond to his ever-shifting allegations, and to frustrate the court's ability to reasonably evaluate his claims by burying them in paper. Improper purpose does not necessarily refer to bad faith or intent to harass. Indeed, any reckless disregard of the duty owed to the court can suffice. Avery has continually misrepresented the facts, misstated the law, and made claims grounded only in speculation with reckless disregard for the truth or falsity. Avery's conduct showed that his many filings, including this one, were filed for an improper purpose. Avery has now filed 6 motions alleging claims that could have been raised in this first Wisconsin State Statute 974.06 motion. He has ignored and attempted to circumvent Wisconsin Statute 974.06 Section 4 by continually labeling his successive motions as supplemental, despite the fact that each of his previous motions had been denied when he filed his new ones, meaning they could not be supplements to his previous motions. State v. Evans, 2004. He has pursued diametrically opposed claims, submitted evidence that he reasonably should know cannot all be true. Avery's 4th motion for remand, 1 through 4, accusing String and Buting of being ineffective for failing to establish Ron Hilligus as the only possible third-party perpetrator, and claiming Sergeant Colburn planted the RAV4, then alleging that they were ineffective for failing to establish Bobby Dassey as a possible suspect, with the same evidence now claiming Bobby planted the RAV4. Further, Avery has inappropriately changed his arguments or raised new ones in his reply briefs, giving the state no opportunity to respond. He has buried and burdened both the circuit court and this court with thousands of pages of exhibits, many of which were unnecessarily repetitive, filed multiple times, and many that were never discussed in Avery's filings. He has leveled completely unjustified accusations of bad faith against the state. And finally, he has disingenuously presented his claims to this court by affirmatively misrepresenting how and when he raised his claims below, changing his claims on appeal, adding new allegations he never presented to the circuit court, and materially misrepresenting the record. In short, Avery has engaged in a pattern of gamesmanship that offends the rules and demonstrates a cavalier lack of candor with this court and the circuit court. The state is not seeking sanctions here. However, this pattern of conduct shows that Avery belated remand requests that have been made for an improper purpose. This court should deny this motion. Again, if Avery no longer wishes to challenge the circuit court's decision denying the claims he raised in the Wisconsin Statute 97.4.06 motions at issue here, he may voluntarily dismiss this appeal. As noted, his new claim is mutually exclusive with some of the claims he raised previously regarding the theory of defense that he believes String and Buting should have pursued, and cannot be squared with many of the allegations in his appellate brief. The process of winnowing out weaker appellant claims and focusing on those more likely to prevail is a hallmark of effective appellate advocacy. Alternatively, if he does not wish to give up his challenges to the circuit court's denial of issues raised in his motions at issue here, he must wait until this appeal is resolved and then determine how he wishes to proceed. But staying the appeal and remanding the case to the circuit court for a fact-finding or another entirely new claim that Avery has not attempted to verify is not appropriate. Avery's request for a remand is contrary to Wisconsin Statute 974.064S, prohibition on successive post-conviction litigation, and then states the rule. Conclusion. The litigation of the new Wisconsin statute 974.06 motion alleging a new Brady violation is not a specific issue related to the order Avery is appealing. It is a new and separate action in the circuit court. Avery has alternative courses of action that do not require further delay to this fully briefed, submitted, and 4-year stagnant appeal. This court should deny Avery's motion, dated this 16th day of April 2021. Respectfully signed, Josh Call, Attorney General. Lisa Comfer, Assistant Attorney General. Okay.
Thank you, Jack, for reading that out. Who's got comments?
Nobody has anything to say.
I do.
No, checking convictions.
Yeah.
Checking convictions.
Go ahead.
They're saying that this is like, it's a lie. I mean, till she, has to prove more. Don't they have to take what she's saying, this affidavit, as truth until they prove it differently?
That's what I thought. But just from what Jack read out, it looks like they're not impressed with the latest filing, and they're doing their utmost to get it tossed out. Nosy Wren. No, sorry, Jack 61.
Just a brief comment, then I'll let everyone else talk. It's I talked about this before. It's just as this case has went on, I think it sticks out to me. He says she's filing all these frivolous different things, but to me, it's like as the cases move forward, more things begin to come out that were buried that we didn't know. I mean, a lot of things we never knew that were unknown in 2007 by the defense, and they've come out now. And as she's finding out more things, I'm thinking, to her, she can't hold on to information for an extended period of time. They won't. Once she finds out, she has a limited period of time to file it. So she can't just hang on to it. So anyway, I'll let Nosy talk.
Oh, I just wanted to point out that Josh agreed with all of us and everyone that this has been an already drawn out and stalled filing, I guess.
Yes.
So I hope that that's paid attention to, that obviously it hasn't been drawn out on Stephen's side. It's because they're not, they're drawing it out on purpose. So I was glad to see him actually put that into writing.
Yeah, absolutely. Thank you, Nosy Wren. Mystic Jinx, do you have a comment?
I think it's interesting that she's that they state that she has not filed a Freedom of Information Act for the call supposedly made, when we know that Manitowoc decided when they were giving the calls to the defense that they were going to just pick and choose which ones went to the defense. So there's a possibility that those calls do not exist anymore because they were never included in the case. So she may have to prove that by his records alone and not necessarily through the Manitowoc Sheriff's Department.
Yeah, that's a very, very good point. And, just to be completely honest, I don't think any of us were surprised by the response by Joshua when you think about it, because remember when when we read the original filing out, what was the very first thing that we all discussed? We all said that Kathleen Zellner has to have corroboration in what was stated by Sawinski, right? We all agreed with that. So essentially, Joshua, he highlighted all the weakness of that affidavit, as one would expect would be done. And he basically said, look, he's pretty upset in a way that Kathleen Zellner hasn't done her due diligence to say, here's the proof, here's the evidence. Bibi, do you have a comment?
They're always cherry picking through her filing and picking the stuff that suits them. to point out which, while they're doing it, they're dragging their heels too. I mean, this one was really fast, but it's
Yeah,
still like they cherry picked through it. All the
yeah,
little
I,
flaws so far that have annoyed them.
yeah, I agree. But it's their job, BB. It's Joshua's, as the Attorney General of Wisconsin, it's his job to slow everything down and hope to God that Kathleen Zellner goes away. It's pretty obvious with the way he wrote this report. Yeah, it's to be perfectly frank and honest, this is exactly what I don't think anyone should be surprised by this response. Jack 61.
Yeah. Yeah. Sorry, Doc. I left my mic open there, but it's also not lost on me how many times he repeated the same thing over and over. He could have probably trimmed. He could have made a reply and got his argument in. Probably, in my opinion, 6 or 7 pages max, and that's max. That's everything, signed page and all.
Correct.
He just drug it out.
Yes, he did. BB, do you have a comment?
Well, they're always complaining that she's long-winded and writes too long and stuff. And it's always asking for extra words, but look at them.
That's correct. 100% correct. Thank you, BB. Alice, do you have a comment?
Kim was asking in the chat. I presume she'd have talked to Stephen before releasing anything. Yes, we do know. I'm sure it was Kathleen that put out a tweet herself, and she said that she spoke to Stephen a week before she released what she had. So Stephen knew for at least a week that this was going to be coming out.
Yes. Yeah. I mean, Zellner representing Stephen will obviously have to clear everything through Stephen. And it only makes, perfect sense that her client is up to speed and up to date with all the filings that she does. But, to be brutally honest, I don't think we would have expected anything different from the state. They were, of course, being very brutal, very disrespectful. They do not even rate Kathleen Zellner, and it's pretty disappointing in my view. Mystic Jinx, do you have a comment?
I'm curious to what they're talking about. Like, they say that he filed something in a previous file that was similar to this, and how Judge Angela Sukowitz has said, denied those claims or whatever. But isn't the reason part of it is that we're at the appeals level is because the circuit court is wrong with their rulings? I mean, even the original ruling of them being guilty.
Yes. I mean, unfortunately for myself, I'm not a legal expert. You really need to have someone with a legal background to understand, how this pans out. But I mean, we can see it from the outside exactly what Joshua is trying to do here, and it's stalling tactics. But not only that, they're trying to diminish the observation of Thomas Sawinski, right? So essentially, what they're doing is they're putting the ball back into the court of Kathleen Zellner. They're saying, okay, you've brought forward this new witness. Now, where's the proof? And Mystic Jinx, you said a very good point. Had Kathleen Zellner said, okay, here's the proof, here's the ultimate proof I have that what Tom Sawinski said occurred, I can bet you that all those records would be gone. They'll be disappeared. So in other words, there's no way there's going to be an official document that backs up, in my opinion, that backs up what Sawinski saw, right? Because then, it's going to be a huge problem for the state if that's the case. Guys, anybody else have any other comments?
There's a question.
Jack 61.
Yeah, there's a question, looks like from Obi-Wan. He says, how do people feel about Wilbur Siebert's statement or testimony stacked up to the this new person's affidavit, do you think it contradicts anything?
Well, Mystic Jinx, do you have a comment?
Yes, it contradicts the statement. It contradicts Ramlow's statement too. I mean, it's a contradiction to both of those people's statements. It's like an investigation needs to be done to see which one is true.
We know people's memories are, they can fail them, and it's not nefarious in any way, but you get mixed up on dates. I don't know how old Siebert is, but wasn't he an aged man, pretty old? I mean, he may have got the date mixed up. I'm not saying he's wrong. Maybe he saw exactly
what. I don't know about that, because wasn't there calls that were from Siebert on one of those things, like his daughter or something was calling about what he'd seen, like the same week that everything's happening. So Siebert might be even a little more credible than, say, this guy whose call we don't have, or Ramlow, who never did make the call. He just says he saw a cop. So
right. It's possible.
Kind of makes Siebert a little bit more credible in my opinion.
If that call, if he actually called on November 5th, like he says it's in this thing here, if he called on that date, we should have that call. But I've listened to those calls, and I don't remember hearing it at all. Of course, that only means that
if you check.
Go ahead.
If you check the affidavit, did he actually state that he called on November the 5th?
I thought I think that's just what it says here. Right.
I have an awful feeling that the state is putting in all the missing detail. For example, someone had commented that Joshua said that Sawinski saw someone pushing the RAV uphill. Well, excuse me, it wasn't being pushed uphill. It was actually being pushed into the Avery salvage yard. That's a huge difference. So, in other words, I think what the state are trying to do, they're trying to cover all their bases, and they're also trying to trivialize the affidavit of Sawinski, and they put the ball directly in Kathleen Zellner's court to say, hey, you need much more proof rather than just an affidavit like this. That's the impression I get. Jack 61.
I was pulling up this document here to see if I can find it. I'm not sure I've got that document. No, go ahead. Let me mute here.
Yeah. So, the bigger question for me is, does the state actually believe Ramlow? Does the state actually believe Siebert? Have they given any credence to those observations? Because it seems to me that they're making a really poor excuse now for the brand new observation by Sawinski, right? So the question is, if the state does believe Ramlow, if the state does believe Siebert, then that is proof that the RAV4 was off the Avery salvage yard. You've now got another witness in Sawinski stating exactly the same thing. Now, I agree, you don't know whether Sawinski actually did see Bobby Dassey. It could have been somebody else, but that's not the point. The point is, why is his observation any more valid or invalid compared to, say, Ramlow or Siebert, right? Because when you think about it and distill it down to the bottom line, all three individuals have stated they saw the RAV4 not at the pit, but it was off the salvage yard, and Sawinski stated that he saw two individuals, yes, he did name Bobby Dassey, pushing the RAV4 onto the salvage yard, right? That's in complete contrast to what the state has been saying all along. Wizard, do you have a comment?
Yeah, briefly. We know how Kathleen Zellner likes to physically get down and dirty with all of the claims that she's looking to raise. She examines everything very closely and she carries out whatever experiments she can. Now, she owns a RAV4. So I'm wondering, has she been to the yard with the RAV4 to see whether two, well, guys, one young, one old, could feasibly push it from the 147 entrance through the yard to where they found the RAV? That would be interesting to see if it's contained
That
in
would be
her
very
tweet.
interesting.
Oh, we were at the yard with the RAV. It can be done.
Yes.
It would be
No, Wizard,
interesting.
that's a very good point. But the question is, will the Avery family actually give her permission in order to carry out that experiment? Because I'm sure they've had a gut full of everything themselves, and I don't know. Checking convictions. Do you have a comment?
Yeah, Kelly says, playing devil's advocate. What if there is no record? What if he didn't contact an officer, but a dispatcher? Whose duty is it then if LA didn't know the call existed?
Yeah,
I think
it's a
I want
tough
to
one.
mention here real quick.
Sorry,
Ronald
Sammy.
had brought up, he said basically she just needs to say, hey, look, they did not investigate this. So ultimately, that's all that she has to bring up for this to raise all of these questions. There's so much more that they do have that's tangible that we know they didn't investigate. So, yeah.
Yep, correct. And the state has the power, of course, to search the documents, search the records, search the phone calls to see whether there's any veracity in the affidavit, right? It's in their court as well. They can now check. They can fact check. So it's interesting that Joshua says, "Oh no, Kathleen Zellner had to do that," when all that information is with the state. So it seems rather bizarre that they tried to put the onus on Kathleen Zellner. Jack 61.
And as far as the checking the records, as we all know, that I've tried to find out retention, and it's different for different retention policy for different things. For electronic kind of things, it's 3 years. Last update that I got.
Fine.
So if that call, if this call, is part of the record that got pulled, Rookie got the 3rd to the 12th from Manitowoc. As part of the record, if that call was actually pulled, but it wasn't included in what he received, and I've seen all the calls. We recorded them; they're available, in one of our playlists. Anybody can go listen to them.
Yes.
That call that call may exist. They may, I'm saying, and I'm not accusing, some cop of, hiding it over here. But then again, I don't trust them. That's me. That's my opinion. I don't trust their motivations.
But
ahead.
Here's the problem, Jack 61. If what Sawinski stated is real and actually took place, and there is a corroborating call or a document, let's be honest here. Do you think that record would still exist now?
Not in any form that would be easy to get to. If it did, I think it would be in somebody's sock drawer, stuck in the back of a garage.
Yeah, or in someone's file, or in a safe.
That's right.
This is the proverbial shell game.
Yes, it is. It is, and it's gonna be who cracks first. Just Rhonda, do you have a comment?
A question from Bethany Marcy. How much did he investigate properly before filing this against Casey's motion? I think that's a valid question.
Yes, yes. Yeah. Look, I mean, if the state is serious about this, if the state is absolutely serious about this new claim, you could betcha that they're checking all their records to see if there's any veracity in what Sawinski has stated, because if true, is extremely damaging, right? So I can't believe that the state is just going to simply leave this to Kathleen Zellner. They'll be checking their own records as well. Mystic Jinx, do you have a comment?
And we should FOIA those 8 emails again, because the next thing we'll know is we'll be like, where is the 8mm tape? Where is this call of this person? You know what I mean? Like, So
Yeah.
maybe those FOIAs and the Calumet County Investigation Report 2.0, we need to start checking that soon again for more
Yes.
adds to
Yes.
that as well, I think. Yeah.
Yep. Very, very, very good point. Bibi, do you have a comment?
Yeah, Jinx had pointed out the other day that it might be the call where the guy called in for his friend who had seen the RAV, had a RAV sighting, and he had called the newspaper, and he was really, really scared and freaked out.
Yes.
And now his buddy was calling. She said that might have been him for all we know. And that call does
Correct.
exist. Yeah.
Correct. So that's very, very interesting. So, again, we really have to wait to see what Kathleen Zellner does next. But I'm absolutely convinced that the state is going through all their records and files just in case they miss something. Neverly, do you have a comment?
I do, and I don't think that it's going to help the cause at all. But just as a reminder, in the 1985 trial, when Stephen had 16 alibis and how many
Yes.
witnesses, and they did
Yeah.
not take any of that in account, even though they were verified and there was even the CCTV footage there, they still dismissed everything. How in the world can somebody provide enough proof to the state to see that there's this witness? And I mean, is everybody else lying and they're the only ones that are telling the truth? As I said, this is really not helping the cause because you can't win with this, I'm just
No.
expressing my
Correct.
frustration, and I'm sure I'm not the only one. As I said, no matter what you present, they will argue and fight that's their job after all. Even if there's
That's
not
correct.
this, corruption or whatnot, that's their job. But it's getting
That's
old.
correct.
It's all ping pong. Oh, you said this, I said that. No matter what you present, they're gonna always kick it out. So, what's one to do? What's one to do?
Yeah, that is 100% correct, and it is extremely frustrating. Mystic Jinx, do you have a comment?
I thought their job was to find truth and justice.
Well, yeah, that's exactly what they're meant to do, but it's pretty obvious here that for some unknown reason, all the rules have flown out the door when it comes to Stephen and Brendan. And it's pretty obvious that they're not going to make things easy, especially for Kathleen Zellner. And, quite honestly, they're treating her with complete disrespect. But again, I don't have a legal background. And I know this sounds funny. It's almost like Kathleen Zellner has to phone up the state and say, all right, tell me how you want me to write this new brief. How am I meant to properly submit it? Because it's ridiculous that Joshua and Lisa are essentially telling Stephen's attorney what should have been stated, the approach that she should have taken. It's here in black and white. It would have been better if you had done this, if you had done that. It's just completely insane. Jack 61.
I did get this document pulled up, his affidavit, and I wanted to fact check Mr. Josh Call. And before I move past it and get to this, if you remember his last brief, how he treated her the same, in the exact same fashion, probably maybe even a little bit worse, and the way he addressed her, it was bad. I do think it also, and I think I've made mention to other people, I think it's as of note that he is the one handling this case and not, say an AAG per se. The last several he's done himself. And I think that speaks volumes, and because, he is the head of the head of the group, the Justice Department per se. So his word, carries more weight. Anyway, I just wanted to get that out there. Anyway, going through this is his affidavit. And 3, I was employed in 2005 at Gannett newspaper. Then on Saturday, this is number 4, Saturday, November 5, 2005, I was delivering papers at the Avery salvage yard in the early morning hours before sunrise. I drove down Highway 147, turned onto the Avery
Yes.
Road. I'm trying to see here if he says that he actually called, which is and I didn't see it earlier. I just kind of scanned through it again. After I learned that Teresa Halbach's car was found on November 5, I contacted the Manitowoc Sheriff's Office and spoke to a female officer. I reported everything I have stated in this affidavit to the officer. They said we already know who did it. I provided my phone number, so forth. But it doesn't exactly say that he called on November 5. It's non-specific.
No, that's correct. And you see, what's disingenuous is that the state have ad-libbed. They've added their own bits and pieces to the response,
Yes.
which is not true. We actually don't know the exact date when Sawinski actually phoned in, and potentially he may not have phoned in. He may have walked in. He may have spoken to an officer, right? We actually don't know whether he made contact, right? But the mere factor that the officer said, "Oh, we already know who did it," tends to indicate that it couldn't have been the 5th, right? Had to be at a later date when they had the forensic evidence coming in, unless someone's doing another Nostradamus, right? Like Jacobs did. Is Stephen Avery in custody yet? And that's before any information is known. I mean, the state is playing hardball. The state is playing dirty. The state is using laws to protect themselves, to put a wall in front of them, right? But, Kathleen Zellner, it's not her first rodeo. She knows the game that these guys are playing. Neverly, do you have a comment?
What you just said and what I said earlier, to clarify what I meant by stated job to figure out to protect, I meant it's in Wisconsin. In this case, is they take it upon themselves to protect the verdict. That's what I meant. It's their job.
Oh,
You know what I mean?
yes, it is.
To, yeah,
Yes, it is.
they're
And
just
look,
protecting the verdict. And who do we have? Josh
correct.
Paul and yeah.
Correct. We mustn't be surprised, guys, by the response, because as Neverly alluded to, and of course you guys alluded to, and we discussed this many, many times, their number one job is to protect the verdicts, right? They cannot afford to overturn the verdicts and release both Stephen and Brendan. And the reason for saying that is that the ramifications of doing so, we know, are immense. Don't worry about the money. Even Stephen said he's not worried or concerned about the money. It's the ramifications of a reversal of their convictions. It's going to have a ripple effect absolutely everywhere, right? And that's why they're playing hardball. And people have commented in chat, correct. You've got Ramlow's observations, you've got Siebert's observations, and now you've got Sawinski's observations. The question is, can they all fit together? Are they mutually exclusive? The answer is we don't know where that RAV came from, right? That's the key point. We don't know where the RAV was stashed, because we know that on the flyover on the 4th, they didn't see it. Jack 61.
And that goes right back to what we've already discussed, and I don't want to mix topics up too badly, but these emails that Ricky was able to get, and that email that between KZ and Fallon emailing,
Yes.
everybody in the world about that 8mm tape. This is one more thing. It's undisclosed. It's not on a ledger that I'm aware of. And it's like they don't care. So for Josh, I think, Josh Call, he says all this stuff, you've had every opportunity in the world and all this other bunch of stuff. The fact is that there's been too much that has been held back. And this, again, leads to what else do we not know about?
Yeah.
So.
Yeah, I know. In the affidavit, Sawinski states, no, I'll read it out. He goes, after watching season 1 of Making a Murderer, I contacted Avery's trial attorneys to inform them of what I saw. I never heard back. So that obviously couldn't have been Strang and Buting, right? Because
His trial
they would
attorney.
have been
Oh no! At that time, no, absolutely not. That would have been Kathleen.
right.
But the
Yeah,
thing
but
is, he said he contacted the trial lawyers. So
That's
what does
right.
that even
the
mean?
trial attorneys.
That's right.
And do we have any information or knowledge whether Sawinski contacted Strang or Buting?
I haven't heard
Well,
anything, but as I understand, oh, go ahead. Who's talking? Alice?
Alice?
well, I seen a tweet that Jerry had put out saying that they knew nothing
Yes.
about this. It was just somebody that had retweeted it that I'd seen, and he put out that they didn't know anything about this witness. But not only that, I mean, I'd like to know myself what trial attorneys they're talking about, because
Yes.
Stephen didn't have an attorney or anything like that after Jerry and Dean. So was it the
It
one
would have been
before Jerry and Dean
would have
that
been
he
public
spoke?
defenders, I think. Would have been public
Yeah,
defenders. Checking
yeah.
convictions.
Yeah, I was just going to say the time that they called, if been determined at trial.
Yeah. So,
The post conviction,
whether
right?
yes, post conviction. So, hopefully someone will come forward and say, yeah, that's right, I do recall. But then again, right, it's a terrible situation, right? Because if Sawinski went up to those attorneys and said, look, this is my observation, how come it's taken so long for it to come out now? It seems rather bizarre, in my opinion. Mystic Jinx, do you have a comment?
Maybe he went into their spam folders.
Hey, you went
No,
into the where?
the spam folder, like maybe
Oh,
they never got the emails or whatever, however he contacted them.
Yes.
Yeah, it's possible.
Yes, because all jokes aside, guys, one could imagine that there probably would have been hundreds of tips coming in, all the time, people making observations and making all sorts of wild claims. And so one has to give weighting as to what is potentially more relevant rather than just a wild rumor. So, it would not have been easy.
Oh,
Certainly
after
would not
ma'am?
have been easy.
After ma'am, it was a
Yeah,
madhouse.
correct.
I do have a
Correct.
question. I do have a question other than what I just said about the spam stuff. Wasn't it like an accident that they even found the Colburn call where he was calling in the plates? Like, wasn't that something that they figured out at like one of the hearings, and that's how he even got the, what is it, several calls that they picked and chose to put into that CD for them? Like,
That was
wasn't
the
that
August.
accidental for that?
That was an August 2006 hearing that Remaker, Buting, or Strang I won, asking if he had refreshed his memory by listening to, whatever calls, and he says, "Well, yes." Of course, I'd open the door up and say, "Well, we've been trying to get these calls for months, Judge. What's going on here?"
Right. Yes.
I do
Could
have,
that be used
I have
against them?
something to mention here.
Sorry, Sammy?
There's a lot of discussion going on about who the lawyers were at that time, but my point here is this that bothers me is he just says in there that he contacted the trial lawyers. So
Yeah.
what does he even know about that? Who did he actually? It doesn't name who he spoke with or who he contacted, because it could mean anything. He could have the wrong name.
I did read something. I want to interject, and then I'll mute again. But I did read, and it's a good point. In 2016, this is years later. Even if he had contacted Buting and Strang, they were under no obligation to do anything with it at all. They were not his attorneys. No. So I hate to say that, but that's just, you think, well, they got this big tip. Well, maybe they did. I'm sure they were getting hundreds of messages, thousands of messages.
Yeah, they would have. And you're right. Have a look what Ramlo did. Right, Ramlo did exactly the same thing. right? After watching Making a Murderer, I think it was season 2, he recognized the fact that he had seen the vehicle at the turnaround. He went into the Senex station. He said, I set it to Colburn, right? So in other words, after people watched Making a Murderer season 1 and season 2, it obviously tweaked certain events, and people thought, yes, that's right, and they made a connection. So I'm not surprised by Sawinski's report. I'm not surprised by it at all. Sammy.
I'd like to mention on here that Bethany Marcy said you can see a small SUV hidden behind a stone pile in the quarry on the 4th flyover. It's extremely quick. You have to pause, but it's definitely there. Very interesting.
Yes, I mean, again, it's an interesting observation, but we have to be extremely, extremely cautious, right? Because, you know, how come when they did the flyover, no one saw it, right? They obviously were looking for a RAV4. Okay, don't worry about the color per se. A RAV4 is a distinct looking vehicle, right? Now they did an extensive flyover everywhere, right? Everywhere for hours. They didn't report seeing it, right? So, yes, it's an interesting observation, but again, you have to show a little bit of caution and a bit of skepticism. Alice, do you have a comment?
Yeah, I mean, just the way they're going on in that reply about her stringing it out and everything like that. They're the ones that have convicted 2 people on 2 different bloody scenarios.
Correct.
Yeah,
That
they've got
that
a
is correct.
that Zellner keeps bringing out these scenarios left, right, and centre. At least the ones that she's bringing out are you can fit to the narratives. You can put we've worked out some of the things for it. But the way the status are that two different people have been convicted for 2 different things for killing the same person, it's just laughable.
Correct. It is, but unfortunately, they were successful, right? The
Yeah,
Yeah.
jury found
yeah.
both Stephen and Brendan guilty, right? Despite different scenarios. Uh, we've been through this many, many times. It is ridiculous. However, a jury found Stephen and Brendan guilty. Now, remember, with Brendan's case, there was no forensic evidence to tie him to Teresa Hallbach or to any crime, right? So that's what you think about it, right? That's why there was such an aggression to ensure that Brendan never got released, right? Brad Schimmel, he made sure that he appealed after appeal. Well, if you have a look what's happening here with Kathleen Zellner, she's facing exactly the same wall. It's a legal wall. Mystic Jinx, do you have a comment?
Well, I have 2. I want to just mention, going back to the trial lawyers, not only were they getting probably a lot of tips, I don't know if everybody remembers, but they were also
Mm-hmm.
heartthrobs of Making a Murderer, so they were probably getting hit on a lot too. And
Yes,
secondly,
but yeah.
okay, sorry, go ahead.
No, no,
Go
no.
ahead.
Keep going, Mrs. Jinx. Keep going.
The
Keep
second
going.
thing is you said something about a RAV being a distinct car and having its own kind of look, but in all actuality, there is the Honda SR-V, which actually looks just like the RAV4,
Oh,
except it's
yes.
a Honda.
Oh, yes. Correct. Absolutely correct. There are many vehicles that have the similar type of footprint. But anyway, they're looking for a vehicle that has the same type of shape as a Toyota RAV4, right? And if they saw something in a quarry or something like that, they would have noted it down and just checked. They would have checked with the workers in the quarry, or what type of vehicles do you possess, etc., etc. But it seems like none of that has been done. But here's the important point. The important point is that when they did the flyover on the 4th, they didn't see a Toyota RAV4 on the Avery salvage yard. That complements what Earl Avery has been saying all along, that both him, I think it was Robert Fabian, they were down at the pit area. They drove through the pit area on a golf cart. They didn't see a Toyota RAV4 because that vehicle would have stuck out, right? Now, complement that with the observation of Ramlow, the observation of Siebert, and now the observation of Sawinski. If you distill it down to its basic, it means that the victim's vehicle was not at the pit, right? On the 4th, it was outside of the Avery salvage yard. That's damaging. Jack 61.
And we've got a couple of questions from a few minutes ago. Another one from Owie. He says, I see that this new affidavit does fit Blaine's account. That is quite significant. Would there be any evidence left that corroborates this new witness and the statement he provided in his affidavit?
Well, I mean, at the moment, it's his affidavit. There's nothing that is in his affidavit that backs it up. In other words, another document or another witness. There is another witness, and that's the older gentleman with the long grey beard, right?
That they've been trying to identify.
They're trying to identify him. Now, I'm not saying that Sawinski saw Bobby Dassey, right? I'm not saying that he did, but the obvious thing is that if you're the state, wouldn't you go now back to Bobby and say, Bobby, is there any truth in any of this? Of course, Bobby's going to say no, right? So hence, the obvious thing is, who is the other gentleman with the long beard? Because he's an independent witness, right? So
That's
if
right.
you can find out who he was, potentially he can set the whole record straight. Okay? Now, if you're Bobby, you're not going to say, oh yeah. I was pushing the RAV4. Yeah, no worries. No, you're not going to get that. Bobby was re-interviewed by Deirdre back in 2017. Bobby said he's got no involvement whatsoever. Point
Right.
number 2 is that it could be a case of mistaken identity. Instead of being Bobby, it could have been somebody else, right?
Potentially.
But clearly they need to find out who the other gentleman was that was pushing the RAV, right? And he
Right.
ducked down beneath the window as if to say, I don't want to be seen or identified. So there is the potential to corroborate that observation. Mystic
But
Jinx, do you have a comment?
why would that guy come forward if he knew what he was doing was wrong?
You do a plea bargain. That happens all the time. I mean,
But
how
why
do you think
implicate
a lot of...
himself at all?
Well, that's true, but here's the problem. Someone may know who he is.
But can they?
And
Somebody may
come
know that
forward.
he hung out with the guy that had a long beard and was older. I mean, does that really prove that he was on the road with him?
No, it doesn't, Mystic Jinx. I'm just giving potential scenarios. There could be plea deals. I mean, we know of a lot of cases that only got solved because someone did a plea bargain, right? They were part of nefarious activity, but they got they got a favor from the state by coming forward and saying, yeah, look, this is what happened.
Here's
Will it
another
happen
scenario.
in this case? I have no
Here's
idea.
another
Yes,
scenario.
Mystic Jinx.
You said he could be mistaken, and maybe not. Maybe it wasn't Bobby. Maybe the guy's mistaken on not who it was, but when it was and what kind of car it was. So maybe the guy pushing the car would be like, no, that was my car. It was a green, van or something that we were pushing down.
Yeah.
Maybe that could
Yeah.
happen, but
But wouldn't it be great though if they did come forward and say, oh no, he got the date wrong, we were just doing, but it seems rather odd that, because remember, he delivered the newspaper to the Avery salvage yard, right? And I think you're the one that found the actual copy of the paper, and it had about the disappearance of Teresa Horbach on the front page and some additional information on the inside cover. So, the fact that it actually tweaked his mind and he informed the Manitowoc's office, look, this is what I saw. Um, I don't know. Unless it can be corroborated, um, I don't think the state's going to do a damn thing unless it can be corroborated. That's the impression I get. Alice, do you have a comment?
Yeah, I mean, just to reiterate, and a lot of people have been saying it in the chat and that as well. The fact is that KZ isn't going to be silly enough to put out a fact or a statement like that and not have anything to back it up with. The amount of stuff that she's done so far for Stephen, do we honestly think in the panel or on the chat that she's going to throw all that away just on this guy's say so?
I don't.
I don't see it. I don't
No,
see it at all. She's
no,
not
no, I
that
don't.
gravid. Her career that's on the line with everything that she's doing in this case. So anything that I mean, there might be stuff out there that people can say, oh, but she said this, she said that, she said, yeah, that's fair enough, but you've got to remember, she's playing a game here. And her game is to
Correct.
in front of judges to get an evidentiary hearing, and then if she can't get that, to take it to the highest court possible to get this man out of jail. So she's not going to be daft enough to let something like that out and not have anything to back it up.
Yes, you definitely need to back it up. And but don't forget, right? This is one person's observation. She's got Ramlo, who saw the RAV at the turnaround. That means that the RAV4, if that was Teresa's RAV4, it meant that it was off the Avery salvage yard. She's also got Siebert, who saw two vehicles come into the Avery salvage or at the back of the quarry the day before, right? And it all seems to mesh with what the way Chuck saw the lights near his property. So everything seems to fit. So she's actually got other witnesses that have seen the RAV off the salvage yard. This is another rod in the fire, so to speak. What the state are trying to do is ignore everything. That's exactly what they're trying to do, especially this one. Neverly, do you have a comment?
To ignore and dismiss, correct, because that's in their best interest, and everybody's looking
That
for their best interest, right?
that's correct.
Yeah.
That is
And to back
correct.
you up, what you said, the power of a plea deal, that it happens all the time. Remember Sean Rudy's case, what he did to his pregnant wife?
Yes,
Who was
his
it
girlfriend.
that turned him in?
His
His
girlfriend. His
girlfriend. She only got
girlfriend.
9 months. She could have
Yes, that is
gotten
correct.
years and years, decades as an accomplice, as guilty by
That's right.
association, right? But she struck
That
up
is
a deal
correct.
and she got 9 months. So who's
Yeah,
to
she
say,
was. Yeah,
everything is possible. Everything is possible. That the
yeah,
guy's
she
gonna
was a
say,
material.
okay, here's the deal. Yes.
Yeah, she was a material witness. She was a material witness to the murder, and she did a plea deal, right? And so, she got a light sentence, and Sean Rudy got convicted for murder. So,
Yeah.
look, anything is possible. The thing is that there's so much heat now on the case. Someone's going to crack. There's a lot of heat, and it's just unpalatable. But I just want the comment I want to say is I do feel very, very sorry for the Avery and Dassey family because the spotlight has come firmly back on them again,
Yeah.
again.
Yeah, well, to come to that comment, Doc, Jeff Jones in the chat has put Scott Tadgett's trailer was 1 mile away from the East Twin River turnaround, so you had Colburn on one end and Scott on the other watching.
Yeah, that's right. The turnaround is very, very close to where Scott Tadlich's property was. Yeah, I know there's all these bizarre things that all, when you look at them in isolation, doesn't mean very much, but when you look at it overall, it's a very damning picture. Jack 61, do you have a comment?
I do, and I want everyone to take this with a grain of salt or a brick of salt if you want. But this observation probably wouldn't come, but for what happened, a couple of weeks ago with the release of the secret video or audio that was taken by DCI Wish and Dettering of that interview with Scott and Barb, and
yes,
I know that there was a lot of anger, and I'm sure there's anger still again right now, maybe probably even more in some ways, and I get it. But at the same time, let's think about what happened after KZ released her PCR and the 2 supplements, and then what did they do? They immediately went to Barb and Scott. I'm sure they knew that they were mad as hell. I mean, right, wrong, or indifferent. That's the way it is. And now here we are, a few years later. Do you think by chance that they're on the horn to him again? I'm just saying, because part of what we heard in that interview, as we talked about, was dividing the family, splitting the family.
Yes. It is. But think about this, guys. Bobby Dassey was specifically named.
That's what I'm saying. That's what I'm saying.
Right. And I saw Bob in chat saying, they're all innocent. They're all innocent. But to me, this cannot be ignored. Either Bobby Dassey was there or Bobby Dassey wasn't there.
It needs to be investigated.
It's a real worry that Sawinski specifically named Bobby Dassey.
It is.
Sawinski didn't say, I saw 2 unidentified males. No, he actually, in other words, what was the motive for Sawinski to specifically name Bobby Dassey? Right, that's all I'm saying. Please, I'm not pointing the finger at anybody, but it's a real concern when a potential witness says, I saw him. That's pretty damning.
Doc, and everyone, we would be hypocrites if we just say, oh, we're going to ignore this because, whatever. We have to follow what's in front of us, no matter where it goes. If we don't, we're just being hypocrites. And, I don't want us to be that. I want us to be as unbiased as we possibly can. That doesn't mean we don't feel for, everybody involved. I mean, these are real people with real lives, and they've lost. And that goes from, the Averys, the Dasseys, the Hallbachs, and there's other fallout even among that. And it's not that we don't care and that we don't feel, we do. But we got involved in this because we see a major miscarriage. So that's all I got to say.
In my opinion, absolutely 100%. And, the only comment I want to make is that there's no winners in this. Even one day, hopefully Stephen and Brendan will get released and exonerated. The fallout's still going to be huge, right? It's not going to be a happy ending story. There's going to be more pain, I'm afraid. Jack 61, do you have a comment?
I saw Susan sneak in the door here, and her mic was unmuted a minute ago. But
okay.
What's going on, Susan? Welcome to the chat.
Thank you. It's a little late.
Susan, you got any comments, Susan?
I don't know what I was going to say earlier, but I'm just going to say that I think KZ knows what she's doing. She has her reasons for asking for the remand, whether she has any proof or not of Sawinski. She has reasons behind this that, we don't have any idea of possibly. So I trust KZ with what she's doing. And, we can speculate all we want, but that gets us nowhere.
That is correct. That's correct. I mean, at the end of the day, it's in the hands of the lawyers. This is very much a lawyer versus lawyer situation, because you look at all the statutes that are being quoted, it's got to be done in the proper legal procedure, the proper legal manner. But remember, this is just the state responding. It's not the judge, right? So that's just an opinion of the state. So now we have to see what happens next. Guys, any other comments? Right. I think we're all exhausted, I think, from that. But it's good that we can come together and discuss this as a group. I mean, I'm not surprised by the response by the state. I think that's exactly, we saw what the weaknesses were in the initial filing, in the initial affidavit, and that's precisely what Joshua did. Looked at the weaknesses and just tried to blow up the whole thing. Checking convictions, do you have a comment?
Yeah, I just want to make a comment that eyewitness at the 19 penny, and that is how good eyewitness identification is. So this guy could be very wrong, but it has to be proved. I just wanted to point that out.
Correct. And I think Neverly pointed out in the 1985 case, Stephen had 16 material witnesses, and the state ignored all of them, right? So that's precisely what they're doing here. They're just essentially ignoring all the witnesses that saw the RAV, right? So now we have at least 3 that we know of that have seen the RAV, and it was outside the Avery salvage yard. But to me personally, this particular sighting here, if true, is extremely, extremely damaging. Jack 61, are you able to just take over the conversation for a little while, and I'll be back in a second?
Absolutely. We'll see if
Thank
we've
you.
got. Yeah, no problem. Are there any, before I move forward with anything else, is there any questions that checking convictions, or Sammy, anybody notice anything in particular that we need to get discussed here before we wrap this up? We're at about an hour and a half. So, Susan, if you remember what you thought about a minute ago, I got sidetracked there, and I was gonna call on you, but.
Well, I just actually got home from work, and I haven't even had a chance to hear this or read it. I heard bits of it, so I don't know. I don't have a lot of knowledge on this response yet. So,
Well, just think about that last brief that you read of Josh Call, that really long one. It's sort of in that same vein. He really just kind of went after it, and he was really pretty disrespectful in the way he talks about Zellner and her approach to how she's done this. But he's basically saying, you're just filing a bunch of frivolous things to slow down the process, and you can't really do that. We're not going to bring any charges on you, but it was kind of I caught that. I don't know if anyone else did. It was kind of a semi-threat to say that, well, if you just keep doing this, there could be ramifications for you doing this. But
come on.
Yeah, I mean, I don't remember what page it's on, but you'll see it there when you read it.
So they're basically just doing the same thing they did with Stephen Avery's witnesses from 85 and ignoring it. That's what they do best, and they deflect, and that's pretty much all it amounted to.
Yeah, I mean, it goes back to control, and they've controlled everything from the time probably prior, but definitely from the time the RAV was found. Everything flowed from the RAV. We talked about this the other day. It led to, cops getting called. They showed up, search warrants. Everybody ran off the property. They maintained it for 8 days, and so this is a whopper. I don't even want to speculate any further than what we already have about whatever calls.
Sorry, Susan.
I was just going to say, I can't believe they wrote 23 pages. What did they have, like 48 hours time or something?
Well, yeah, basically.
They probably had it they probably had it all pre-planned, right? As soon as they got wind of that particular affidavit, they just took out the same old crap that they've used before and compiled it all together. Because if you notice, they quoted all the particular statutes. They've done that many times before. So there
Right.
was really nothing new or mind breaking. They just basically what they're trying to do is to discredit the eyewitness,
Yeah.
discredit Sawinski and his observation, discredit the way Kathleen Zellner presented the brief in the first place,
Mhm.
and basically saying, hey, look, we're getting tired of all the mountains of paper. They're getting tired of all the mountains of
No
paperwork.
shit.
It's the biggest joke out. It's Kathleen Zorner that's doing all the hard work and presenting all the filings. And they see, it's funny. It's almost like they're putting a price on what it takes to release someone who's falsely imprisoned. They're
Right.
basically saying, hey, look, guys, back off a little bit. We've got too much to deal with over here. Whereas Kathleen Zorner's putting on the pressure all the time. And remember, Kathleen Zorner said, oh, this case is nothing compared to some of the other ones that I've dealt with. And she's won, but it takes many years to do it.
So I
Bibi,
have a
do you have a
question.
comment? Oh, sorry,
Yeah,
Sam.
just real quick.
Sorry,
So
Bibi.
you think
Yeah.
you think Joshy Boy pulled an all-nighter on this one?
Probably. I would say probably. Look, it to be brutally honest, it wouldn't have taken them too long to do, because they would have had previous responses from her other filings. They just simply modified them. They used all the appropriate statutes that they've quoted before, and they've basically tried to shoot holes in the way Kathleen Zona presented her latest filings. It's nothing new. We've seen it. We've seen it before, BB. Jack 61.
How many times did he mention the statute 874.6? It had to be a dozen and a half times. It was ridiculous.
That's correct. So, they're putting up the legal shutters. They're putting up the legal block. And so Zona, she's done this before. She knows she's going to keep on persisting. Neverly, do you have a comment?
Yes, she's done this before, so I'm gonna just continue on to that one. And she said it before. In other cases, the state was willing, more than willing, to look into things and say, oh, wow, they wanted to do the right thing. And what do we have here? The opposite, quite the opposite. They will do anything and everything to do their part, to protect their interest, to protect their verdict for the obvious reasons. As you said,
Correct.
there's so much at stake over here that it's not even Stephen Avery and Brendan Dassey. There's just so much more. It's not even the money. So if they were willing, they would go and follow up, but they're not.
Yes. No, they're not. And to be completely honest, I don't think this has got anything to do with Stephen and Brendan anymore. They're trying to prove a point that they don't want to overturn those convictions, because if a corruption probe is to take place, all the stuff that occurred in the 80s and 90s and beyond, all that's going to be reinvestigated, potentially reinvestigated. And I'll tell you what, the fallout will be immense. So they're using the typical jargon to block Kathleen Zellner. What they're doing is stonewalling Kathleen Zellner. Now, I just want to make a quick comment, right? We're going to you think about this. Look at the way the state treated their own county coroner. That's all I have to say. If they treated their own county coroner in the manner that they did, do you think they're going to show any respect to Stephen, Brendan, and Kathleen Zorner? Right? No way. Right? If they can treat the county coroner Deborah Catch in the manner that they did, you know how these guys work, right?
Good point,
They're deadly,
Silkman.
they're deadly serious. They're not going to muck around. And I'll tell you what, this is not going to end well. Okay, it's going to go right down to the wire. So if they treat their own representatives, their own elected officials like crap, they've got no time for Stephen, no time for Brendan, and absolutely no time for Kathleen Zellner. It's as simple as that. That's my comment. Susan, do you have a comment?
I was just going to say they threatened her. They scared the crap out of her. The coroner.
Correct. And
Yeah.
yes, and just to let you guys know, or you probably already do know, that's what we're going to be presenting as our presentation for Paul Capaldi's Keep on Talking while they walk, keep on
Till
walking.
they're walking.
Mini ma'am.
Yeah,
Keep
the
on
mini man.
talking till they're
Mini
walking.
mamathon. Yeah.
Yeah, we're gonna be presenting the what they did to the coroner, and keep that in mind because the timing is perfect. Look at the way they're treating Kathleen Zellner. Well, we're now going to delve into how they actually treated one of their own, and it's shocking. All right.
I want to know, is it not in their interest when these things come up and these filings are made for them to check that there might possibly be any evidence or proof for this? Or is that foolish on my
Well,
part to even think that they should?
yes, it is. Yes, it is because what they're
Yeah.
doing is they're putting the onus. They're putting the onus on Kathleen Zellner. They're saying, "All right, you've presented this affidavit. Now prove it." They're
So,
not going to do. They're not going to do her legwork, Sammy. They're not
oh
going to
no,
do it
but I'm
for her.
saying on their own part so they don't get blindsided with something they didn't know was there and how stupid of them to not know.
I
But
would say, yes.
on the other hand, I'm wondering if she does have proof for this and it does not come from either Minotaur or the other, and if this is something that they couldn't possibly know she has the potential to produce proof for.
Well, I'll tell you how she could do it, and that's to find out who the female officers were taking the phone calls and find out. And that's exactly what the state is terrified, because if you notice in the report, what did they say? Oh, she could have easily found out who those officers were, and we could have checked. How do you know that she hasn't already done that and got a statement? Say, yes, I was on that night, and yes, I did receive that call. Boom, away you go. Alice, do you have a comment?
Yeah, I was just going to say, I mean, the last time Stephen got out of jail, it was going to cost the state $36 million. If they keep this
Yes,
going the way they're going, it's going to be a hell of a lot more than $36 million that they're going to need to pay out for Stephen and Brendan. So you would think the
that's
common
correct.
would do was check these facts, and if they're that sure that their evidence will still stick to this day, then give Stephen another trial. But that's the problem. Too much has came out, and there's no enough evidence against Stephen or Brendan. And in my opinion, I don't think they would get another conviction with everything that's came out. So they're just playing silly games now, and it needs to
Yes,
stop because it's going to cost them. As we said before, it is going to cost them, and the shit is going to hit the proverbial fan big time.
that's correct. So, the other potential outcome is that you have a trial 4 outcome, and that is, oh, look, we're going to release the guys. We still think they're guilty, but so much time has gone so much water has gone under the bridge. It's going to be very difficult to do another trial, so we're going to release them, but they're still guilty, right? That's exactly what happened in the trial 4 situation. So you never know. You never know that outcome may occur because Kathleen Zellner knows that if she gets she gets her time in court, she's going to let rip. She's going to let loose all the information that she's got. She's got a whole bank of professionals. It's going to look pretty bad for the state. That is for sure. All right, guys. We've been going, I think, pushing nearly 2 hours. We've had some great discussions. Are there any other quick final comments?
Well, there are some questions that were here and some comments.
There's always questions.
Right. TTM Fangirl would like to know, does anybody know or have a picture of that story where a dad see his daughters or heard his daughters saw some people in a fire in the quarry? Something about girls in a fire in the quarry. She's looking for that if anybody can help her. And then Odog says it aligns with Earl in seeing the Rab midweek. It aligns with Chuck not being home to go to his house. It aligns with Bobby work schedule. So if this new witness was trying to play a fast one, I doubt he doubled his research. It says it aligns with the palm print. It aligns with direct Rav was eliminated facing. I don't know facing what that means unless it lines up. He's talking about the palm print lining up.
The way
It aligns with the direction.
Yeah.
Yeah.
And then it says
the way the
lots of
rapport was
reasons.
placed.
Right. Lots of reasons for KZ to think that it's legit. That was Odog.
Yeah. That's the worry. It all fits. And there was the opportunity to do exactly that. That's the issue. But it needs to be corroborated. Just Rhonda, do you have a comment?
Yes, I will. I'm just going to make a couple of comments for Obi-Wan. He says, I'm just acting on good conscience and unbiased, but is it quite possible that he had heard this in the news and followed the case for quite some time? I'm sure he knows about the award. He already admitted that he came forward after learning that the RAV4 was found on the Avery salvage yard. That in itself creates an issue, as he's already been contaminated by media reports.
100% correct. There's only one thing. Well, no, actually, there's several. One, if the guy with a long beard comes forward to corroborate, the chance of that happening is 0. And 2, the caller that Sawinski phoned, if that caller comes forward and says, yes, I did receive a call on this date, then that corroborates what Sawinski stated, right? So the bottom line is this, and Obi-Wan makes a good point. You need corroboration. Now, what Obi-Wan also applies to Brendan Dassey, right? Because Brendan Dassey got information from the media, from his family, and concocted a story. So you're right, it's contamination of facts, of ideas, and you concoct a story. But Sawinski is not going to get $1 unless there's a conviction. Is that correct, Jack 61?
That's right. They got to have they got to have some kind of corroboration for this.
That's it. So all the onus is actually not on Kathleen Zellner, but on Sawinski, right? Because he's going to get into trouble if he made a false affidavit. And even Joshua highlighted that, right? He highlighted that in the response that, you don't want, if you're spreading false information, you're going to pay the price for it. So the onus is on Sawinski, not Kathleen Zellner.
That's right.
So there has to be a form of corroboration. Jack 61, do you have any comments?
To TTM Fangirl's question, I do remember what she's talking about, and to my knowledge, there are no photos, to my knowledge. So that's all I do remember it. That I'll just, until we get done, Doc, I'll just stay unmuted.
Yeah, no worries. No worries. Guys, do we have any final comments? Are we all good? Oh, Bibi.
I think Fangirl was looking for the screenshots of the statement or something.
Oh, right. Screenshots
of that. The guy whose daughters seen the fire or whatever.
Wasn't that a call, not a statement? I thought it was a call. I don't know, though.
I can't remember. That's way back. I just don't remember. If I run across it, then I'll try to get it to her.
Yep, I do remember hearing something like that, and it could be in one of Kathleen Zellner's filings as well. So it's a matter of just checking. But I do recall that story. Correct,
Yeah.
correct. Yeah, but you know, to break it down, guys, I'm not at all surprised by the response by the state. Let's see what the judge says. We'll have to basically wait. But hopefully, Kathleen Zellner's got more up her sleeve than just
Do,
the affidavit alone. Mystic
do you
Jinx.
think she's going to reply to this now? Does she have an opportunity to
No,
reply?
that I don't know. But do you really think it's actually worth her while to reply?
Well, if she
That
replies, she could be adding evidence, which could be the proof the call
true,
exists.
true.
Just wondering.
That's true.
That's
I
possible.
don't think
And
she
maybe
has a reply, and on the WSCCA, it says,
Pending.
let's see, awaiting opinion decision. So
Yeah.
I don't believe she gets a reply to this.
right, right, okay. But maybe that's her strategy. Maybe that's her strategy all along. She waited to see what the state was going to say and what the state picked up upon, and then she's going to say, okay, here's the proof that I've got. So you never know the strategy. Neverly, do you have a comment?
I have a question, which is, do we know when the state is going to reply? Any
To-
The
idea?
I
state
mean,
or
court,
The
You mean the
court.
court?
court?
Yeah,
No.
the court.
That I don't know.
but it should be soon. I think the last
I
time
think
it
so
took
too.
2 weeks or something like that.
Didn't they say
But-
somewhere around April or May? Weren't we waiting for that?
Yeah, I don't know the exact
I don't
date,
know either.
Neverly.
Do
I don't.
do they have to
I'm-
reply on this before they like reply or give a decision on the whole like? Because
They
we were
don't-
kind of waiting for them to
they do-
decide on the appeal
No,
Yeah.
in
they
general.
didn't. No, she's asking them to remand it. Now,
Yes,
stop
they
They
it.
have to reply.
reply on that first
Yeah.
before they can make a decision. Okay, just wondering.
Yeah. Because he's basically asking them to halt the appeal process, go back to circuit court and investigate this.
Right.
And of course, they could say no to that and then still make their decision, correct?
Yes.
Absolutely.
If they say no, that's what's up next is their decision on her appeal.
Yeah. And that could be another 6 or 8 months or however the hell long they want to take. Yeah,
Yeah.
exactly.
That's true. That's true. That's true. All right, guys. Do we have any final comments? Are we all good? I mean, of course, we can continue this discussion.
I have one final comment. Once again, I'd like to thank Laura ML for making this document public so we could get on and talk, get it read, and let everyone talk. Get questions and talk about it because, of course, this is on everyone's mind. So I just want to thank her again.
Yeah, and thank you, Jack, for reading out the document as well. Fantastic
Absolutely.
job.
Thank you.
Bibi, a quick final comment.
Yes. Can everybody hit the like button and the subscribe?
Yes, thank you so much. Thank you so much. So, yes, I mean, that's basically all from me. And Neverly, do you have a final comment?
Yeah, it just makes you wonder what in the world would it take for this court to accept something, let alone the state. Short of Teresa walking into the courtroom and say, hey, I'm okay.
Yes.
What would they accept? Because this is such a
well-
long distance. As she said, it takes endurance and patience and follow
That's
through
correct.
and follow up. But I don't
Correct.
understand. I mean, witnesses came, they were dismissed. Alibis, he had alibis, they were dismissed. And this is not the only case that I'm talking about. It's just amazing and mind-boggling
Well,
how hard it is to get somebody out of
Neverly,
prison.
maybe the answer is on that 8mm tape. Right,
Maybe
Texas,
the one
you want?
she's pissing him off, pissing
Yep.
Fallon off.
Maybe the answer is on that tape.
Maybe.
Thorn in my
Yeah,
side. It's a
could
thorn
be.
in my side is all I can say.
Could well be. All right, guys. I think that's all.
Any more questions before we head out for anyone?
I'm all good.
Okay. All righty. I'd like to thank everyone for coming and showing up with us on this unusual night. And we'll see you next time. This has been a Foul Play production. And we're done.
Woohoo!
Good.